When someone is arrested for a DUI in California, there are actually two separate processes that begin. One through the criminal court system and one through the DMV. Let's focus on the DMV part. Here's what happens. When you were arrested, the officer likely gave you a pink piece of paper. That's the DS-367 form. That is your temporary license and also a formal notice that the DMV plans to suspend your driving privileges. The suspension doesn't start right away. You have a small window of time, which is only 10 calendar days from the date of arrest, to call the DMV and request a hearing to fight or delay the suspension. Here's the important part. If you fail to request the hearing within 10 calendar days of your DUI arrest, that suspension is automatically going to happen 30 days from the day of your arrest. And guess what? In those 30 days, you may not have time to take the steps that you need to take to be eligible for the type of driver's licenses that you could be eligible for after suspension. But if, on the other hand, if you do request your hearing within those 10 calendar days, it puts a pause on the suspension action while the hearing is pending. And it gives your lawyer the time your lawyer needs to prepare your defenses to the suspension action. And even if those defenses aren't strong enough to prevent a suspension altogether, it gives you the time you need to get the pieces in place to help you qualify for post-suspension license options that you may be eligible for.